Thank you very much, Ms. Lopez. Welcome to the Office of Tax Appeals virtual hearing. Before we go on the record, I do want to take care of a couple of administrative issues. Due to ongoing health concerns, this hearing is being conducted electronically with the agreement of all the parties and participants. Today's proceedings will be live streamed, and a certified shorthand reporter will also transcribe the oral hearing. The transcript and video recording are part of the public record and will be posted on our website. So here are some general rules just to keep in mind when we do this hearing online. Please say your name before you speak. This is just to ensure that everyone is aware of who is speaking. And also, do not speak while someone else is talking. It'll be very difficult to understand what's being said. Webex does have a chat feature. Please don't use that because that will not be part of the public record. And please mute your microphone if you're not speaking to avoid any feedback or background noises. And just as another reminder, this is being broadcast live, so any information you share on your screen will be publicly viewable. Just want to make sure everyone's well aware of that. Also, it's my understanding that Ms. Gozukara, your translator or your witness, Mr. Soilemez, he's only there to help you with the more complicated terms. It's not that you need a full translation. Is that correct?
Yes.
Okay, great. Then let me introduce myself. My name is Daniel Cho. I'm the lead administrative law judge for this hearing, but all three members will be co-equal decision makers. It's my understanding that the issues in this appeal are whether the Office of Tax Appeals has jurisdiction over this appeal and whether appellant is entitled to a refund. Is that your understanding as well, Mr. Cooper?
Yes, it is.
Thank you. Department?
Yes, that's consistent.
Thank you. With respect to the evidentiary record, the department has provided exhibits A through D, D as in dog, and the appellant has provided one exhibit. Neither party has any objections to the evidence. Is that still the case, Mr. Cooper?
That is the case.
Thank you. Department?
Yes.
Great. There are two stipulations that will be read into the record. The stipulations are, number one, at all relevant times, Ms. Gozukara was not liable for any unpaid sales or use taxes administered by respondent. The second stipulation is, Mr. Gozukara is personally liable for the unpaid taxes of Urban Automotive Group, LLC, in the amount of $79,833 in tax, plus accrued interest and penalties of $7,983.30. Is that correct, Mr. Cooper?
Well, the amount that was given to the state under the lien when the property was sold was $141,298.26. So the request for refund is $141,298.26 plus interest from that date forward.
Okay, but that's the amount at issue in this appeal, but with respect to the personal liability for Mr. Gozukara.
That is correct.
Okay. Department, is that your understanding as well for these stipulations?
Yes, I agree with what you read.
Okay, great. And we are off the record right now. It may seem a little repetitive to do this twice, but I found that when we take care of all these things off the record, when we go on the record, it'll be a very clean transcript that you can read through. All right. So that's all that I have for administrative issues. Does anybody have any questions before we go on the record? Mr. Cooper?
No questions.
Department?
No questions. Thank you.
All right. Ms. Alonso, are you ready to go on the record? Looks good. All right. Let's go on the record. This is the appeal of AGOP Gozukara, OTA case number 19085-195. Today is July 21st, 2020, and the time is approximately 10:06 a.m. This hearing was originally scheduled for Cerritos, California. However, due to the ongoing health concerns, we are holding this hearing electronically with the agreement of all the parties. My name is Daniel Cho, and I will be the lead administrative law judge for this appeal. With me are administrative law judges Win Dang and Andrew Wong. Can the parties please introduce and identify yourself for the record, beginning with appellant?
Catherine Gozukara.
Steven Söylemez.
Daniel Cooper, representing the appellant.
Thank you. And department?
Hi, for the department, my name is Joseph Bonniwell, and with me today is Monica Silva and Jason Parker.
Thank you. The issues in this appeal are twofold. One, whether the Office of Tax Appeals has jurisdiction over this appeal, and two, whether appellant is entitled to a refund. With respect to the evidentiary record, CDTFA has provided exhibits A through D, and appellant has not objected to these exhibits. Therefore, these exhibits are entered into the record. Appellant has submitted exhibit 1, and CDTFA has not objected to this exhibit. Therefore, this exhibit is entered into the record. There are two stipulations that we're putting onto the record today. One, at all relevant times, Ms. Gozukara was not liable for any unpaid sales or use taxes administered by respondent. Two, Mr. Gozukara is personally liable for the unpaid taxes of Urban Automotive Group, LLC, in the amount of $79,833 in tax, plus accrued interest and penalties of $7,983.30. With respect to the presentation, Mr. Cooper, you'll be going first with your opening. But before I do that, Mr. Söylemez, I believe you will be acting as an interpreter for part of this proceeding. Is that correct?
Correct.
Then I'll put you under oath as an interpreter, and then afterwards, I'll put both of you under oath as witnesses. So first, Mr. Söylemez, would you mind raising your right hand? Thank you. Do you solemnly swear or affirm that you will truthfully and accurately translate from French to English and from English to French?
Yes.
Thank you. You can put your hand down now. And now for Ms. Gozukara. Would you mind raising your right hand?
Yes.
Okay. Do you solemnly swear or affirm? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. If at any time you don't understand what's going on, Ms. Gozukara, please ask us to stop and have Mr. Söylemez translate for you.
Yes.
Thank you. And now, Mr. Söylemez, would you mind raising your right hand one more time? So now you'll be taking the oath as a witness. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you very much. Okay, Mr. Cooper, the floor is all yours.
Do you want to start with the jurisdictional issue first?
It is up to you on how you wish to proceed with your presentation. You can do your opening and then examine the witnesses if you like, or you can just skip to the jurisdictional issue. I will leave that completely up to your discretion at this point in time.
Well, with regards to the judicial issue, excuse me, the jurisdictional issue, in the event that the appellant does not prevail at this hearing, I have recommended that we seek a judicial review. And in order to do that, we have to exhaust our administrative remedies. So the concept of exhaustion of administrative remedies is fundamental to administrative law. The courts require the person to seek relief at the administrative level before resorting to the judicial branch. The exhaustion requirement gives the administrative agency, the opportunity to correct its own errors. Judicial remedy will be denied if a party fails to exhaust administrative remedy. In the matter before this panel this morning, the Office of Tax Appeals is the final step in the exhaustion of administrative remedy. If the Office of Tax Appeals does not have jurisdiction, how can my client exhaust her administrative remedy? Therefore, we believe that the Office of Tax Appeals does have jurisdiction to hear this matter, to allow the appellant to seek the judicial remedy if necessary. And that's what I have to say about that issue.
Thank you very much. And Mr. Cooper, if you don't mind, would you mind trying to speak into your microphone a little bit? It's a little hard to hear you. I can still make out what you're saying, but it's just a little difficult.
Okay, is that better?
That's much better. Thank you.
Okay, sorry about that. Okay.
No problem.
All right. So should I go into my opening statement then?
Sure thing. Please proceed.
All right. The chain of events leading up to this hearing this morning and the denial of the request for refund of the sales and use taxes is based upon the following facts, which I do not believe are in dispute. In 2008, the Orange County Superior Court entered a judgment of dissolution of marriage between the appellant and her husband, Gozukara. The judgment of dissolution awarded the Newport Beach real property located at 1640 Galaxy in Newport Beach, California, to the appellant as her sole and separate property, and awarded the business and all tax liabilities associated with the business to Catherine, to appellant's ex-husband. The respondent has stipulated that the appellant is not responsible for the delinquent sales taxes, and has stipulated that the appellant's ex-husband is personally liable for the delinquent sales and use tax. 2009, the appellant and her ex-husband recorded a interspousal transfer deed prepared by the attorney who handled the divorce. The interspousal transfer deed documented the following. First, it documented that the Newport Beach property was transferred to a family trust and that effective as of the recordation 2009, Catherine's ex-husband did not have an ownership interest in the property when the respondent lien was recorded in 2011 because he was not a beneficiary of the trust. Under California law, the transfer of appellant's sole and separate property to trust is not transmuted and to joint ownership. So petitioner became the successor in interest to her ex-husband, and the Newport Beach property remained appellant's sole and separate property after the transfer. Testimony will show that numerous creditors were removed from the preliminary title report when the property was sold, based upon the recognition of the interspousal transfer deed, and that the Newport Beach property was the sole and separate property due to the court order of the appellant. Secondly, that there was a transfer to a former spouse in connection with a dissolution of marriage. The interspousal transfer deed states that on its face, and we will show that when we go through the exhibit. Under California Civil Code 1213, the filing of an interspousal transfer deed is constructive notice to the respondent that there was a transfer of real property to a former spouse in connection with a decree of dissolution of marriage. In a decision that was entered previously, one of the arguments was that the department did not have notice that there was a transfer, and our argument or our position is that the department is presumed to have notice because that's what the interspousal transfer deed states. The respondent's tax lien was recorded in 2011, and the appellant will testify that prior to the respondent's filing of the tax lien, she had no knowledge that the business or that her ex-husband owned any delinquent taxes. And under California Government Code 1710, a state tax lien is not valid against a successor in interest without knowledge of the lien. Appellant never received any notice of the lien. Appellant was never notified by her husband that there was a tax lien. And she discovered the lien when the preliminary title report was obtained, and it was disclosed on the preliminary title report that the state had filed a lien and had attached to the Newport Beach property. In conclusion, the denial of appellant's claim for refund should be set aside, and her claim for refund granted based upon the Newport Beach property was appellant's sole and separate property. Appellant was not liable for sales and use tax at issue. The appellant's ex-husband is personally liable. Appellant had no knowledge of the tax lien and their applicable California law. The recording of the interspousal transfer deed in 2009 placed the department under constructive notice. And since she had no knowledge of the tax lien is invalid. Appellant's ex-husband is liable for the delinquent sales and use tax when the respondent tax lien was recorded. Ex-husband had no interest in the property because the Superior Court granted her the Newport Beach property as her sole and separate property, and therefore the lien is unenforceable against the appellant. Thank you. The first witness I'd like to call would be the appellant, Catherine Gozukara. And Catherine, I believe, has already been sworn in, is that correct? Oh,
Mr. Cooper, we cannot hear you very good.
did anybody hear my presentation?
I did. Now we hear man much better.
Okay, let's try to get a lean forward there. So, Ms. Guzukara, do you mind if I call you Catherine?
Yes.
Do you mind if I call you Catherine?
Yes.
No.
You don't mind? You don't mind?
Qu'est-ce qu'il dit?
Est-ce que tu peux appeler Catherine?
Yeah.
You can call her Catherine.
Yes, Catherine.
Okay. Are you currently married?
No.
Okay. Have you been married?
Yes.
And who are you married to?
Agop Gozukara.
Okay. Are there any children from this marriage?
I have two children, Michael Gozukara and Alain Gozukara.
Okay. And how old were your children when at the time of the separation?
11 years old.
Both, one was 11 years old.
Yes.
What about the other?
Alain, he has 11 years old.
And what about the other child?
He's a Michael,
How old was he?
21.
Okay, very good. And when did you file for dissolution of marriage? When did you file for dissolution of marriage?
Dissolution married?
Yeah, marriage, yes.
Um,
Was it 2008?
is a May 2008.
Okay, that's fine. And was a judgment of dissolution entered?
Is a November 19, 2008.
Okay. And did the court order a division of the marital property?
Yes.
And what did the court order? What did the court order say?
My house for me and the dealership to my husband, ex-husband.
Yeah. So basically, the court, at the conclusion of the dissolution of marriage, you wound up with the Newport Beach property. Is that correct?
Yes.
And he wound up with the business, correct?
The business is for my house. Sorry, for my husband, for my ex-husband.
Yeah. And the tax liabilities and debts associated with the business. Is that correct?
Yes.
And did you have anything to do with the business? While
No.
the business was operating?
No.
Did you receive any financial gain from the business?
No.
Okay. And my understanding is that you had a damage awarded because of an accident,
Yes,
and that's basically what you were living on. Is that correct?
yes.
And did you and your husband file a interspousal transfer, an interspousal transfer deed?
Yes.
Okay. Would you please turn to Exhibit A?
Is a grand deed.
No, item number 8, interspousal transfer deed.
Oh, yeah, okay.
Okay. And have you seen this document before?
Yes,
Okay. And that's you and your husband's signature, correct?
yes.
Okay. And who prepared this document?
My divorce lawyer, Amy Ness Agnon.
Okay. And when was it recorded?
November 19, 2008.
Okay. I believe it was March 11th, 2009. If you look at the upper right-hand corner, it says
Oh, yeah.
March 11, 2009.
Oh, I'm sorry. Yeah, okay.
That's right. Do you have any idea why this was transferred to the family trust?
I don't know.
Okay. When the interspousal transfer deed was signed, were you intending to transfer an interest in the Newport Beach property to your ex-husband?
Never.
Okay. Was your understanding it was your sole and separate property, correct?
Yeah, before sell my house.
Okay. Would you, on that interspousal transfer deed, would you please read that box that's checked in the middle of the page there?
Is,
Okay, is a transfer a spouse or former spouse
And let me-
in connection with the propriety statement agreement to decree a dissolution of married of legal separation.
Okay. So basically, that document states that this interspousal transfer deed was recorded because this is a transfer to a spouse or former spouse in connection with a property settlement agreement or a decree of dissolution of marriage or legal separation. And this was prepared by your divorce attorney, correct?
Yes,
Who was aware that the Newport Beach property was your sole and separate property, correct?
yes.
And now please turn to Exhibit 5 of the appellant's exhibits. Exhibit number 5 is the grant deed.
Yeah, it's a grand deed.
And this was recorded in May 7th of 2015,
Yes, May 7, 2015.
right? And according to this, you and your husband signed it as trustee of the family trust, transferring it to you as an unmarried woman. Is that correct?
Yes.
And you know what the purpose of this grant deed was? Purpose of the deed? You know what the purpose of the grant deed was?
Excuse me, I need to French.
pourquoi ils ont raccordé cette grande, le titre?
Because my house for me is the dealership to my husband.
Yeah.
No? Yeah.
Okay. So basically, this was to transfer it out of the trust to you as your sole and separate property. Is that correct?
I don't know.
Okay. Well, according to the deed, you are the sole owner of the property, effective effective when the transfer deed was filed, effective when the court order was issued, and now this is basically to justify that. Did you sell the Newport Beach property?
Yes.
And did escrow close in 2018?
Is January 23, 2018.
Okay. And Were you aware that there was a state tax lien prior to the sale of the property?
No,
Okay. Did you ever receive any correspondence from the state of California indicating that there was a lien?
no,
Okay. If you received any mail addressed to your ex-husband, did you open any of that mail?
no,
Okay. Did you forward it to him?
no,
Did you receive any mail addressed to your husband after the divorce?
Oh, after the divorce, yes.
And what did you do with anything that you received addressed to your husband?
I just open et talk.
Did you forward it to him?
Je peux, can I translate for her, Ms. Cooper?
Yes, please.
Quand tu as reçu de lettres pour Agop, est-ce que tu as donné à lui?
Non, j'ai pas donné. Je lui ai dit au téléphone qu'il y avait problème avec les taxes. Because il vit pas avec moi.
She said he wasn't living with me at that time. I told her that she has a mail or tax problems. I'm not sure.
Okay. So your ex-husband did not live with you after the divorce, is that correct?
No, never.
Okay. Did he ever tell you that he owed the state of California money for delinquent taxes?
Est-ce que tu disais il doit payer l'argent de l'État de Californie pour le impôt?
Yeah, il doit payer, mais comme il a
Non,
pas
est-ce que
d'argent.
est-ce que
Oh non, 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 non.
demande?
Never, no.
Real quick, I'm sorry. Just to remind Mr. Soilemez, when you act as an interpreter, please only interpret the question and the response.
Okay.
Thank you.
Ms. Guzukara,
Yes,
when you sold the property, did you receive all of the sales proceeds from the sale of the property?
no.
What happened to a portion of the sales proceeds? Was the lien paid off? State tax lien paid off?
No.
Okay. When you sold the property, you wound up, you paid off all the debts and you wound up with some cash. Did you receive all of the cash, or did some of that cash go to the state of California?
No.
Well,
I think I need to translate for her. She didn't get it. The
okay.
question. Quand tu as vendu la maison, est-ce que tu as payé l'État de Californie l'argent?
Oui, oui. I'm sorry. Yeah, oui, oui.
Yes.
Oui. For sell my house, yes, because I can't sell my house.
Do you know how much went to the state of California?
Is 141,000.
Actually, that's correct. Okay. All right. So is it your testimony that you were not active in the business of your husband's, correct?
No,
You derive no financial gain for the business?
no,
Prior to the sale of the Newport Beach property, you were not aware that the business was audited by the State Board of Equalization?
excuse me, can I have French?
Not
Est-ce que
audited.
vous savez, avec le boulot, il y avait des investigations de taxes sur la boulot de Agop Gozukara?
After, yes, yeah.
Were you aware that the business, you were not aware that the business owned delinquent taxes, correct? You were not aware that there were any business taxes owed?
Tu ne savais pas qu'il y avait des impôts sur la dealership?
Before sell my house, yes, I don't know.
Okay, all right. I have no further questions.
All right. Thank you, Mr. Cooper. Department, do you have any cross-examining questions for the witness?
No, we don't. Thank you.
Thank you.
Okay,
Panel members, do you have any questions for the witness? Judge Dang? I'm sorry, Judge Dang, you're still on mute.
This is Judge Dang. I do not have any questions.
Thank you. Judge Wong, do you have any questions?
Hi, hi, this is Judge Wong. I just had one question. Was there any thought given to recording the judgment of dissolution or the stipulated judgment that was attached to it?
I believe Mr. Soilmez might need to translate that question for the witness.
Could you repeat again, please?
This is Judge Wong. Sure. I was just wondering whether there was any thought given to recording the judgment of dissolution or the stipulated judgment that was attached to it. That was the document in, I believe, late 2000, November 2009 or 2008. Sorry, November 19th, 2008. That gave the property to appellant. Was there any thought to recording that?
Is that question for me or for her? Should I translate to her? I don't think she would know the answer of that question. Est-ce que 2008, quand vous avez séparé et la tribunal qui t'a donné la maison, pourquoi vous n'avez pas accordé sur le titre de la maison sur toi?
Ah, ça, je sais pas. I don't know.
This is Judge Wong. Okay, thank you. I had no further questions.
Thank you, and thank you for reminding me. This is Judge Cho. I should also be introducing myself before I speak. So the floor goes back to you, Mr. Cooper.
All right, I'd like to call Stephen Solimez as a witness. Mr. Solimez, do you mind if I call you Stephen?
Go ahead, Mr. Cooper.
Okay. Would you please introduce yourself, Mr. Stephen?
My name is Stephen Soilmez.
Okay. And what is your occupation?
I'm a licensed real estate agent.
Okay. And what agency do you work for?
I work currently for Villa Home Incorporated in Long Beach, California.
Okay. And what is your relationship to Catherine Gozukara, the appellant?
I met Catherine and her ex-husband in 2002. I've sold 1416 Galaxy Road in Newport Beach to them.
So you've known Catherine and her husband since 2002, is that correct?
Correct.
Were you aware that Catherine and her husband were divorced in 2008?
Yes.
And is it your understanding that the court awarded the Newport Beach property to her as her sole and separate property?
Yes.
And were you involved in the subsequent sale of the Newport Beach property?
I was.
And in connection with the sale of the property, was a preliminary title report obtained?
Correct.
And did you assist in removing certain encumbrances or liens attached shown on the preliminary report?
Well, approximately, there were at that time, I think, was 18 to 19 encumbrances recorded against the property. And I personally went to title company, First American Title Company, and they requested to have a divorce document. And I went to the courthouse, actually, got a divorce paper to the title rep, the title agent, actually. And her name is Debbie Talganetto at First American Title. And they removed most of them.
Okay. Would you please turn to the respondent's exhibit A and attach that as their exhibit A? And that's exhibit number 8. And turn to page, I'm sorry, it's exhibit 2, the third title report. Could you turn to page, do you have the third title report there?
Page what?
Let's go to page 4. Starting with number 12. That appears to be some sort of a writ of attachment dealing with Urban Automotive Group LLC. Is that correct?
Correct.
And you had that removed, showing that the Urban Automotive Group had no interest in the
Correct.
property, correct?
Correct.
Let's go to item number 13, which shows the debtor as Gozukara. You had that removed, is that correct?
Correct.
And you went to number 14. Here again, that was another judgment against Catherine's ex-husband, and you had that removed, is that correct?
Correct.
And number 15, you had that removed.
Correct.
And number, the next page, number 16, this was certified copy of judgment for an abstract thereof recorded March 27, 2014.
That's paid.
That was paid?
Yeah,
Okay. And then number 17,
that was not paid.
that was removed, correct?
Removed. Correct.
Real quick, this is Judge Show. This might be a good time to interject something. Mr. Soilimus, please remember to wait until the question is completely asked and then respond. This way, there's no crosstalk. Thank you.
And did you address with the title company the state tax lien that was addressed to, the debtor was Heather's ex-husband?
Could you ask me the question again, please?
Did you address the state tax lien for $79,000 for the back to sales and use taxes with the title company? Did you try to get that removed?
I tried that to be removed, and initially the title rep said yes, but afterwards he said, well, we don't want to have to be sued by state of California. So that's, they didn't remove it.
Okay. And did you assist the appellant or Catherine in attempting to resolve that lien with the state of California?
Correct. After that, we applied for franchise tax board in Irvine. Actually, me and Catherine went there. We have applied for that to be removed. And this was the direction of title company. They sent us there. They said they are the one who should remove it. Just show the divorce paper, they should remove it.
And that was the Board of Equalization, not the franchise tax, right?
Yeah, I'm sorry, Board of Equalization in Irvine, Von Carmen.
All right. When did you become aware of the Board of Equalization tax lien?
When first time we pull out the preliminary title report.
And did you discuss that with Catherine?
I did discuss with her, yes.
Yeah, and did she indicate to you that she was not aware of it?
She did tell me she's not aware of it and she's not responsible for it.
And therefore, I believe you contacted me, is that correct?
Afterwards, yes, we have contacted you.
Yeah, all right. And were you involved in selling the Newport Beach property?
Yes, I did.
Okay. And at that time, I believe you and I discussed the tax lien, is that correct?
Correct, we did.
Remember what I told you?
Yes, you told me to pay it and we will, afterward, we will open a case with the state of Board of Equalization.
You know how much was out of the sales proceeds went to the state of California?
$141,293 some cents, I believe.
Okay, good. All right, well, thank you very much, Stephen. I have no further questions.
This is Judge Cho. Thank you. Department, do you have any questions for the witness?
This is Joe Bonniwell of the department, and we don't have any questions for the witness. Thank you.
Thank you very much. Panel members, do you have any questions for the witness, starting with Judge Dang?
This is Judge Dang. I do not have any questions for the witness.
Thank you. This is Judge Cho. Judge Wong, do you have any questions for the witness?
This is Judge Wong. No questions.
This is Judge Cho. Thank you. All right, Mr. Cooper, I believe that sums up your witness testimony. Do you think you can finish your presentation in the next 10 minutes or so?
What did you wish? Am I not going to hear the other side?
The department will go after you're done with your presentation, and you'll be given 5 minutes on rebuttal.
Okay, so what do you want? You want my closing statement then?
Sure, but not your complete. Well, do you want to skip your presentation right now then, let the department go? And
I
you give
do.
a final closing?
Yes, I would.
All right, great. In that case, department, now's the time to do your presentation. Thank you.
Thank you. This is Joe Bonniwell for the Department of Tax and Fee Administration. On the first issue, which is whether the Office of Tax Appeals has jurisdiction over this appeal, we were asked to review Regulation 30104 Subdivision D, which states that the Office of Tax Appeals does not have jurisdiction to hear whether the appellant is entitled to a remedy for the department's actual or alleged violation of any substantive or procedural right, unless the violation affects the adequacy of a notice, the validity of an action from which a timely appeal was made, or the amount at issue in this appeal. So insofar as the Office of Tax Appeals determines that none of these applicable exemptions under Reg 30104 Subdivision D apply to this appeal, it's the department's position that the Office of Tax Appeals does not have jurisdiction to hear this matter. We would note, however, that in the matter of the appeal of Ray J. Ponek and Mary Ellen Ponek, ODA case number 18011900, decision issued September 10th, 2019, the Office of Tax Appeals considered whether it had jurisdiction to consider the propriety of a department levy and whether it was proper. In that case, the Office of Tax Appeals determined that based on Regulation 30104 Subdivision D, it did not have jurisdiction to consider the appellant's contentions concerning the validity of a department levy. In the event that the Office of Tax Appeals does determine it has jurisdiction over this appeal, the department maintains its position that appellant is not entitled to a refund. As discussed by Mr. Cooper, on January 24th, 2018, the department received payment of $141,763.95 from an escrow account containing proceeds from the appellant's sale of real property located at 1614 Galaxy Drive in Newport Beach, California. And we're referring to this property as the Newport Beach property. And the escrow demand letter with this amount is Exhibit 4 of Department's Exhibit A. And the escrow check that the department received for that amount is Exhibit 5 of Department's Exhibit A. So at the time of the sale, the property had a state tax lien attached to it for Mr. Gozukara's unpaid liabilities of $79,833 in tax plus accrued interest and penalties of $7,983. The unpaid liabilities were imposed against Mr. Gozukara in a December 15, 2010 notice of determination, Department's Exhibit B, based on him being a responsible person for liabilities that were self-assessed by Urban Automotive Group LLC for the period of January 1, 2008 through March 31st, 2008. An appellant is now seeking a refund for that amount of the payment and offers several arguments attempting to undermine the validity of the department's lien and its subsequent collection. So to start, there is no dispute as to the validity of the department's state tax lien against Mr. Gozukara. Pursuant to Revenue and Taxation Code 6757, Subdivision A, if any person fails to pay any sales or use tax obligation at the time it becomes due and payable, the amount thereof becomes a perfected and enforceable state tax lien, And at the pre-hearing conference, the parties stipulated that Mr. Gozukara is personally liable for the unpaid liabilities of Urban Automotive Group LLC. Mr. Gozukara failed to pay his liability at the time it became due and payable on January 14th, 2011. Therefore, on January 14th, 2011, a state tax lien automatically attached to all real property and rights to real property belonging to Mr. Gozukara and located in the state of California. And the department's real property lien is the department's Exhibit C. The department later recorded its lien in the County Recorder's Office of Orange County on August 12, 2011. The recording stamp is on Department's Exhibit C. And as relevant here, the lien attached to all of Mr. Gozukara's real property and rights to real property in Orange County, including his rights to the Newport Beach property. And this is supported by the April 28, 2015 title report that's in evidence as Exhibit 2 of Department's Exhibit A. The title report indicates that on June 4, 2007, appellant and Mr. Gozukara had rights in the Newport Beach property as joint tenants. And the title report shows no changes to Mr. Gozukara's rights in the Newport Beach property prior to the department recording its lien. As such, when the department recorded its lien on August 12, 2011, it properly attached to Mr. Gozukara's interest in the Newport Beach property, as reflected in the title report. Despite this, the appellant argues, based on various documents that I'll discuss, that when the department recorded its lien, it did not attach to Mr. Gozukara's interest in the Newport Beach property because at the time the lien was recorded, Mr. Gozukara didn't have any interest in the property. So starting with the judgment of dissolution, this is the department's Exhibit 7 of Exhibit A. With regard to the dissolution, appellant contends that pursuant to the judgment, she held title to the Newport Beach property as her sole and separate property. As a result of the divorce, appellant asserts that Mr. Gozukara had no interest in the property to which the department's lien could have attached. And the dissolution of appellant and Mr. Gozukara's marriage includes the stipulated judgment that was discussed that does award appellant the Newport Beach property. The judgment was entered on November 19, 2008. However, it was never recorded. And a grant deed transferring the property to appellant, which is Exhibit 9 of Department's Exhibit A, was not executed until February 25, 2015, several years after the department recorded its lien. As discussed in the Appeals Bureau decision, California case law indicates that a divorce decree that is not recorded is not effective against a third party without notice. This proposition is consistent with California Civil Code. Section 1217 states that an unrecorded instrument is valid as to parties thereto and those who have notice thereof. And California Civil Code Section 1214, which stands for the proposition that every conveyance of real property must be recorded to be valid against the subsequent encumbrancer. California Family Code, Section 852 further makes clear that unrecorded transmutations of real property are not effective as third parties without notice. The appellant's argument, effectively, is that the judgment of dissolution transmuted the Newport Beach property from community property to appellant's separate property and vested complete title in appellant. However, because the judgment was not recorded and because the judgment was a third party without notice of the judgment, any conveyance of real property contained in the judgment was not effective as to the department when it recorded its lien. The grant deed that transferred title to appellant was not executed until February 25th, 2015, and it was recorded May 7th, 2015, both dates being well past the date the department recorded its lien on August 12th, 2011. So when the department recorded its lien without notice or knowledge of the appellant and Mr. Gozukara's dissolution, the lien attached to Mr. Gozukara's interest in the Newport Beach property, notwithstanding the judgment. So turning to the interspousal transfer deed, appellant makes several arguments that this document prevented the department's lien from attaching to the Newport Beach property. The interspousal transfer deed is Exhibit 8 of Department's Exhibit A. As discussed by Mr. Cooper, the interspousal transfer deed was executed on March 4th, 2009. It was recorded in Orange County on March 11th, 2009. There's a box that's checked on the document that states it is a, quote, transfer to a spouse or former spouse in connection with a property settlement agreement or decree of dissolution of a marriage of legal separation, end quote. And the granting language on the interspousal transfer deed reads, quote, grantors, Agop Gozukara and Catherine Gozukara, husband and wife as joint tenants, hereby grant to Agop Gozukara and Catherine Gozukara, trustees of the Agop Gozukara and Catherine Gozukara Family Trust, the following described real property in the county of Orange, state of California, end quote. And it continues on to describe the legal description of the Newport Beach property. The basis of appellant's first argument with regard to the interspousal transfer deed appears to assume that prior to the interspousal transfer deed being executed, Mr. Gozukara did not have any interest in the Newport Beach property because the judgment of dissolution awarded the property to appellant. As just discussed, the judgment was not effective as to the department. However, based on that incorrect assumption, appellant argues that by transferring the property into the family trust, Mr. Gozukara did not gain any interest in the property. As I just read, the granting language of the interspousal transfer deed states that Mr. Gozukara and appellant both transferred their interests as joint tenants in the Newport Beach property to themselves as trustees of their family trust. Appellant has not provided a copy of the family trust. From the granting language on the interspousal transfer deed, we know that Mr. Gozukara and appellant are trustees of the family trust. And from the February 25th, 2015 granting, Exhibit 9 of Department's Exhibit A, it states that the conveyance is from the family trust to appellant and that it's a conveyance, quote, into or out of his/her revocable trust, end quote. In California, when property is transferred into a revocable trust, the settlor or trust creator remains the owner of the property. So given the evidence that's available to us, even after the transfer as described in the interspousal transfer deed, Mr. Gozukara and appellant still both held legal title to the property as trustees, creating a presumption they both still own beneficial title. And this is consistent with the April 28, 2015 title report, which shows that Mr. Gozukara and appellant both held joint tenant interests in the Newport Beach property from at least June 4th, 2007 through August 12th, 2011, before and after the recording of this interspousal transfer deed. As such, the department's lien properly attached to Mr. Gozukara's interest in the Newport Beach property. Alternatively, appellant asserts that the interspousal transfer deed was intended to fulfill the terms of the dissolution, namely to transfer the real property to appellant. But regardless of the intent, as just discussed, the evidence demonstrates that the effect of the the interspousal transfer deed was to transfer the property from appellant and Mr. Gozukara as joint tenants to appellant and Mr. Gozukara as trustees of the family trust, while the box that is checked on the interspousal transfer deed concerns a transfer to a spouse or former spouse, and it suggests a transfer to one person. It's the only box that concerns a transfer in connection with a property settlement agreement, and it appears to be the most relevant box for the appellant and Mr. Gozukara's transfer. The granting language, which is entered by the executing parties, clearly states that the transfer is from a husband and wife as joint tenants to the family trust. And appellant and Mr. Gozukara acknowledge the effectiveness of this granting language when they subsequently executed the February 25th, 2015 grant deed, which transfers the Newport Beach property out of the family trust and to appellant. The evidence shows that the interspousal transfer deed did not have the effect of fulfilling the terms of the dissolution and did not transfer the Newport Beach property solely to appellant. The final argument I'll address with regard to the interspousal transfer deed is that appellant asserts that the department had constructive notice of the interspousal transfer deed, and as a result, the department should be charged with some kind of actual notice of the judgment of dissolution that awarded the Newport Beach property to appellant. Appellant is correct that the department had constructive notice of the interspousal transfer deed because it was recorded on March 11th, 2009, which is prior to the department recording its tax lien in Orange County on August 12th, 2011. However, pursuant to California Civil Code Section 1213, every recorded conveyance of real property is constructive notice of the contents of that recorded conveyance to subsequent encumbrances. Insofar as the interspousal transfer deed is a recorded conveyance of real property, the department can only be charged with constructive notice of its contents. The contents of the interspousal transfer deed states that it's the transfer from appellant and Mr. Gozukara as joint tenants to appellant and Mr. Gozukara as trustees of the family trust. And this is consistent with subsequent recorded filings. When the department recorded its lien subsequent to the interspousal transfer deed, it attached to Mr. Gozukara's continuing interest in the Newport Beach property. The interspousal transfer deed had no impact on the propriety of the department's lien. It did not effectuate a transfer of the Newport Beach property to appellant. At most, it can be read to a transfer of the Newport Beach property from appellant and Mr. Gozukara as joint tenants to appellant and Mr. Gozukara as trustees of the family trust. That being the case, at the time the department recorded its lien on August 12, 2011, Mr. Gozukara held interest in the Newport Beach property to which the department's lien properly attached. Finally, I just want to address the grant deed. The grant deed was recorded, as I said before, on February 25th, 2015, and recorded on May 7th, 2015. It expresses a declaration and a change of the ownership of the Newport Beach property to appellant's sole and separate property. And we agree that the grant deed transferred the property solely to appellant. However, the grant deed was recorded too late. The department's lien was recorded over 3 years prior, and as such, it did not invalidate or have an impact on the department's lien. The totality of the evidence demonstrates that on August 12, 2011, the department properly recorded its lien against all of Mr. Gozukara's real property interests in Orange County, including his interest in the Newport Beach property. No preceding, intervening, or succeeding actions invalidated or otherwise altered the propriety of the department's lien against Mr. Gozukara's real property interests. The department subsequently released its lien while it was still effective, and the escrow payment was made using the proceeds of the sale of the Newport Beach property attributable to Mr. Gozukara's rights in the property. So based on the foregoing, if the Office of Tax Appeals determines that a jurisdiction to hear this matter, the department requests the claim for refund should be denied. Thank you.
This is Judge Cho. Thank you very much, Department. Panel members, do you have any questions, beginning with Judge Dang?
This is Judge Dang. My question for the department. I agree with the department's position that California is a race notice jurisdiction. Insofar as the language of Civil Code Section 1214, I believe it appears to apply only to mortgagees, purchasers for value, as well as judgment creditors. My question, therefore, is on what basis, or does the department have any authority for us to treat the department's statutory lien arising under Government Code Section 7170 as in the same manner as one of these enumerated items, either a judgment, purchase for value, or a mortgage?
Well, I think the department's position on that is that Section 1214, when it comes to mortgagees, it doesn't just specifically mean a traditional mortgage that is executed when you purchase a property, as much as it can encompass a broader range of subsequent encumbrances, and the department would be a subsequent encumbrancer.
Thank you. I'd like to point out a United States Supreme Court decision. It's U.S. v. Gilbert. The citation is 345 U.S. 361. It may relate here in that the United States Supreme Court found in that case that a local city tax lien, the city was not a judgment creditor within the meaning of a somewhat similarly worded statute because a judgment required some type of court action. If you'd like a moment to review that and respond, if you'd like, please do so.
I would just, in response to that, I would say that we aren't asserting that we would be considered a judgment creditor in the instance that we would have a judgment against the taxpayer in this matter. We didn't. Just like a mortgagor does not have a judgment in order to a right or an interest in property, that is our equivalency here.
I'm sorry, I just wanted to clarify, you're saying the state's taxing is equivalent to a mortgage in this instance?
The equivalency I'm trying to make is that when I say we're a subsequent encumbrancer, I'm not comparing us to a judgment creditor as what appears to be in the Supreme Court Supreme Court case, which I have not read and am not familiar with. But on first blush, I would say that I wouldn't compare us to a judgment creditor if I'm going to distinguish us from this case. And I would compare our status as an encumbrancer to that more of a mortgagee who has a right that arises outside of a judgment.
Thank you. And is the department aware of any authority interpreting section 1214 to encompass all encumbrances as opposed to those specifically enumerated by statute?
I don't have that before me.
Thank you. I have no further questions.
This is Judge Show. Thank you. Judge Wong, do you have any questions?
This is Judge Wong. No questions. Thank you.
This is Judge Show. I don't have any questions either. So at this point in time, Mr. Cooper, you have your 10 minutes for your final closing statement.
Well, the bottom line here, I believe, is that the appellant was awarded the property as her sole and separate property, and there was a Superior Court order to that effect. The department has stipulated that the delinquent tax liabilities, she's not responsible for the delinquent tax liabilities. The department has also stipulated that Catherine's ex-husband is responsible for the deficient tax liability, the delinquent tax liability. There is a court case, 1918 court case, that says a divorce decree is sufficient to vest complete legal title to real property in a party thereto. And that's Carr versus Carr, 1918, 39 Calat 53, the court may determine and decree that a party is the owner of the real property and need not require a deed to transfer title. So it is the appellant's position that the court granted her title. My understanding of the recording statute is to place the world on notice that that the property has been transferred to a successor in interest. However, as the judge indicated, we don't believe the failure to record doesn't mean that the property was not transferred to Catherine, because the court order specifically stated that it was. The transfer to the trust, as I've indicated before, does not transmute sole and separate property to the joint interest in the property. Catherine testified that it was not her intent to give her ex-husband any interest in the property. Stephen testified that when there were discovered a number of liens associated with the ex-husband, that the title company removed all of those liens because they agreed that the property was owned by the appellant. And the only one that they would not remove would be the state tax liability, because they were concerned about the state suing them. So it appears that the title company removed liens that were associated with the ex-husband because he had an interest in the property. So As we've indicated before, and during the testimony, after looking at the exhibits, the respondent's stipulation, and hearing the testimony of the witnesses, it's clear that the Newport Beach property was a sole and separate property by court order effective 2008. As stipulated, the appellant was not liable for those taxes, and as stipulated, her husband, ex-husband, was responsible. The department has not addressed the issue with regards to the appellant's knowledge of the tax lien. Specifically, the code section states that code section 1213, well, let's see. Let me find that. Yeah, with regards to Government Code 7170, it specifically states that tax lien attaches all property rights, whether real or personal, tangible personal, belonging to the taxpayer located in the state. However, a tax lien is not valid as to a successor in interest, which Catherine is, of the taxpayer, the ex-husband, without knowledge of the lien. And the appellant has testified that she was not aware of the lien. She never received any notice for the state of the lien. And she found out about the lien when they pulled the title report to sell the property. So under Government Code 7170, it's clear that the tax lien's invalid. And in looking at this as a matter of fairness, it certainly seems to me like the department, or the respondent, is relying on a lot of technicalities to get money out of someone who is an innocent spouse, not aware of the lien, not aware of the technicalities of transfer deeds and grant deeds and things like that. She relied on her divorce attorney. So therefore, it just seems under common sense that the department's seeking $141,000 from an individual who owns the property as a sole and separate property by court decree, who notified the public as to the transfer deeds that there was a transfer between the spouses with regards to that. I don't know, it just seems to me that, first of all, it's unfair. First of all, the department's not, I don't think the law supports the department's policy. And I think that to deny the claim for refund and not set aside the denial would be unfair, not supported by the evidence, not supported by law, and therefore the decision should be set aside and the claim for refund should be granted. Thank you.
This is Judge Cho. Thank you very much, Mr. Cooper. Before we finish up, panel members, do you have any final questions for either party? Judge Dang?
This is Judge Dang. I have no further questions.
Judge Wong, any questions?
This is Judge Wong. No further questions.
Great. And I have no further questions either. So this concludes the hearing. The panel will meet and decide the case based on the documents and testimony presented today. We will issue our written decision, no later than 100 days from today. This case is submitted and the record is now closed. So we'll take a brief recess before the next hearing, which is scheduled to begin at approximately 1 p.m. today. Thank you very much to all the parties.